Welcome to literary and jury charge practice. Let's start out with this literary material. Ready? Here we go. Since a suit often is time-consuming and expensive, many people are choosing to settle outside of court. The process used is called arbitration. Arbitration usually is not held at the courthouse, but in a hearing or conference room, often the arbitrator's office. Arbitration proceedings are similar in structure to trial proceedings. They contain opening statements, cases in chief, rebuttals, and closing arguments. However, they are more informal. The rules of evidence are relaxed somewhat, but just as in a trial, each witness is sworn in and testifies under oath and can be cross-examined by the opposing party's attorney. There is no jury. Instead, the arbitrator decides the case. A dispute goes to arbitration when a person has signed a contract providing that any disagreements be arbitrated. When a contract calls for arbitration of disputes, the decision of the arbitrator is final. If you do not agree with it, you cannot sue in court and ask for a jury trial. You can, however, ask a court to invalidate the arbitrator's decision if the dispute was outside the arbitration agreement, or if there was some impropriety in the arbitration proceedings that may have affected the outcome. When someone is hired for a particular job, he or she may sign a contract that contains a clause that provides for arbitration. Occasionally in court proceedings, the judge will order the parties in a civil suit to arbitration. When this happens, the arbitrator's decision usually is not binding. If the plaintiff does not like it, he or she can still proceed to trial with the case. When the judge sends a case to arbitration, he or she is simply trying to reduce the backlog of cases in court. He or she is hoping that the case will be settled and will not have to be decided in a court of law. Criminal law differs from civil law in that it prescribes the rules that people must respect in order to keep society from becoming so chaotic. Criminal law really encompasses two distinct areas. The first of these includes the rules defining what is a crime. The second includes the rules that the police, prosecution attorneys, and courts must obey before a person can be convicted of and punished for a crime. Get back to that one. Now let's try this definition of bailment. Ready? Here we go. A bailment may be defined insofar as it applies to this case as a contract for the delivery of personal property for safekeeping and is a contract which is contemplated to be beneficial to both parties hereto, where the bailment is reciprocally beneficial to both parties, as in this case, the bailee, the defendant in this case, is liable to the bailor, the plaintiff in this case, for the failure to exercise ordinary or reasonable care in the absence of a special agreement to the contrary. You are instructed that the defendant was negligent if he failed to exercise the degree of care in protecting the plaintiff's property that an ordinary, careful, and prudent person would have exercised under the same or like circumstances. If the defendant used ordinary care and diligence, then he is not liable. But if he failed to use the ordinary care and diligence that an ordinarily prudent person would have used under the circumstances, then he is liable. The burden of proof is upon the plaintiff to prove by a fair preponderance of the evidence that there was a neglect of duty that the defendant owed to him when the defendant became a bailee of this automobile. Now for this literary, and it is called The Best Profession. Ready? Here we go. The school I teach at recently had a contest for its theory students. The students were asked to write an essay on why court reporting is the best profession. First prize was a full sponsorship to the upcoming Texas State Annual Convention. Their passion for the profession displayed in their essays was so contagious, I wanted to share. The coolest profession in the world. Second runner-up is Kayla Perry, 22, from Conroe, Texas. In addition to studying court reporting, Kayla works part-time as an office assistant at a law firm. Being a court reporter is so much fun, Jill Driscoll, Associate Court Reporter of the 418th Judicial District Court, shared. I still get excited to go to work every day. Court reporting truly is the best career in the world. Although court reporting is extremely challenging, most court reporters would agree that the career is even more rewarding. There are a number of reasons why court reporting is the coolest profession in the world. From captioning to CART to freelancing and trials, there are countless opportunities in the court reporting field. Unlike most careers that require at least a 4-year degree and provide such a narrow window of opportunity, court reporting offers the complete opposite. It allows different people, personalities, and mindsets to excel in the environment they are most comfortable, whether that be in a courtroom, working in a different country, or even in the living room of their own home. There are always new people to meet and interesting things to see, Driscoll added. In addition, not all court reporting jobs have the normal 8 to 5 work schedule. Some positions provide relatively flexible schedules, making life more simple and fun for everyone. I love that I am always being challenged. I am learning something new every day, Driscoll continued. The world is a ball full of information just waiting for someone to soak it all in. One of the coolest things about being a court reporter is that they get to hear, see, and consume new information all the time. The day never fails to bring something new and unique. You never know what the next day has to bring, she said. right, now let's try some of this closing argument. Ready? Here we go. Ladies and gentlemen of the jury, honorable court, and counsel, this is what the defendant told the victim's daughter shortly after he discovered her, within a few days of discovering her dead. Let the county bury her. That kind of sums up the defendant's attitude and gives you an insight as to the mindset of someone who just murdered his wife. The words of the poor grieving widower after his dead wife was, quote, found by them in a chicken coop, apparently from a heart attack, except, well, she was shot in the back with a gun that has his DNA on it. And for some strange reason, the gun and the holster were buried underneath a mound of stuff in the chicken coop, and just happened to be tossed. He tossed the clothes he wore that night in the trash, along with supposedly new clothes he just bought at Walmart. And the clothes he wore that night just happened to have gunshot residue on them. Well, maybe he was able to console himself with the money he made from the sale of the house, valued at $100,000. You didn't hear any testimony about that, but there is an exhibit. By that I mean the value of the house. There's an exhibit, Exhibit 45, Certified Assessor's Records, that says the net value when it was assessed was $110,000. Now that's money he would have been required to share with his soon-to-be ex-wife if she had lived another 3 days until July 11th, 2012, when their divorce would have been final. At least he wouldn't have to pay his wife's medical bills, which was the whole reason for the divorce, he claimed, since he and his wife, he claimed, made too much money for her to qualify for low-income health insurance, but she would qualify if she was single, and that's Harold Anderson testifying, except that her Medicare coverage would have kicked in a month, and that is according to the exhibit, a Medicare card, Exhibit 54. I'm putting it on the screen. I don't know if you can see it real well, but it does say that the hospital coverage and medical coverage kicked in on August 1st of 2012. Now, that's what Harold Anderson said. He said, quote, quoting the defendant, Linda couldn't get health insurance. There was some possibility if they got divorced, she could get some coverage, unquote. That is what he was telling people. That's what he told Harold Anderson. We'll get back to that. Let's try a little more practice from our literary material, The Best Profession. Ready? Here we go. Today, technology is changing just as fast as new information is being produced. With advanced technology comes better, faster ways to write, making court reporting an illimitable career in more than one way. When working, I feel like I am playing a video game. As technology gets better, I get an upgrade to my video game, Driscoll added. The profession has changed tremendously just in the past few decades. It is amazing to know the future of court reporting is boundless. Finally, court reporting is one of the coolest professions in the world because every person has a similar journey that leaves thousands of mentors, assistants, and encouraging words for students and reporters alike. Because this profession is one of the most challenging in the world, it is necessary to depend on one another. The court reporting community is one big family. After 30 years in the court reporting profession, I still have the best seat in the room. Every day brings something new and exciting, Driscoll concluded. There is no other profession in the world that can compare to court reporting. Although this career path is not for everyone, it takes hard work, dedication, and determination to climb to the top of the court reporting mountain. Once you reach the top, the opportunities are endless. There are always new people to see, new things to learn, new technology to look forward to, and an abundance of encouragement across the planet. This amazing profession makes court reporters the coolest people in the world. We will get back to this article and read a couple of other essays from that was the second runner-up, and there's also an essay from first runner-up and first prize. So we will get back to that. Ready? Here we go. Some activities are crimes because they are bad in themselves. Murder is one such crime. Other crimes are bad because they are prohibited by law. If you speed through a stop sign located in a deserted area at 2 a.m. when no one is around but a police officer, your crime is bad because it is prohibited by law. Crimes are further categorized as either felonies or misdemeanors. Felonies are major crimes. Misdemeanors are minor crimes. Felonies are the most serious types of crimes. Mayhem is the act of maiming or permanently disfiguring someone. Today, many other crimes are also considered felonies. Many crimes have evolved because of the advent of the computer. People use the computer to commit fraud and other such crimes. For a crime to be committed, two items must be present: an act, or the physical element, and a particular state of mind, or the mental element. The act is the body of the crime. In a murder, for example, it is the killing of a human being by another human. In arson, it is the burning of a structure. The other element is a mental element. The mental element is the person's intent to do the illegal act. In law, it is frequently said that an act is not a crime if done without a guilty mind. Killing someone, for instance, is not a crime if it was purely accidental or is justified self-defense. It is not a crime because there is no wrongful intent, and just as the act needs the intent to be a crime, the intent needs an act to be a crime. Merely thinking about doing something illegal is not a crime, regardless of how evil the thoughts are. A conspiracy exists when two or more persons agree to commit a crime, but in order for the crime to be committed, more is required than a mere agreement. Right, well, looks like that will conclude our literary and jury charge practice.